It doesn't just go with spanking. On the PFA, it also talks about that he was hitting, spanking, and yelling. Brandon has a lot of domestic violence in his past. He has
essentially, and sole physical possession of the child between now and the next hearing. Is that correct?
Correct. Yes. Yes, Your Honor.
All right. Ms. Smith, your position regarding this temporary request?
Your Honor, my client is objecting to the temporary request. The PFA in Sedgwick County was granted on ex parte orders without any input or hearing from my client, and so that has not been litigated yet. But furthermore, I think it's important to understand that the allegations in the PFA are that my client has spanked the fiance's minor children. The only issue that even went to a PFA and got signed is because those children are not biologically related to him, and so there is a legal question as to whether or not he has the authority to parent those children. That's the only reason that I believe ex parte temporary orders were even signed, is because the allegation is about spanking minor children whom he lives with, whom he parents, but is not a legal parent to. The difference here is that the child that Ms. Hall has filed about is my client's legal child. He is a parent to that child, and so even if everything in the PFA case is true, which my client denies that it is, he denies that he's ever spanked her children. But even if we take that PFA as 100% true, that he has spanked Easton in this case, he's Easton's biological and legal father. He is allowed to parent Easton, and Ms. Hall has not provided anything that would indicate that parenting has gone above and beyond parenting that is allowed in Kansas. For example, we do not have any photos of bruises on this minor child. We do not have any police reports. We do not have any DCF reports. We have nothing indicating that he has gone above and beyond simply parenting his own child, and therefore ask that the emergency order be denied.
Your Honor, if I can interject, there actually is a current DCF case going on right now. There also were past DCF where not only I have contacted, but others have contacted DCF in regards to concerns for Easton's safety. I do have documentation. I have a whole Google Drive full of documentation if needed to prove everything else. It doesn't just go with spanking. On the PFA, it also talks about that he was hitting, spanking, and yelling. Plus, I have other documentations and what my son has said, plus what the other two children have stated have happened in regards to how he handles situations when they're getting in trouble. I have all the documentation right here that I can address if you would like.
Has DCF issued a final report and findings in the case?
Right now, she's waiting to speak to Brandon. She knows of our case hearing today. She knows of the PFA hearing on Thursday. So she just spoke to me yesterday stating that she was going to talk to Brandon later this week, possibly after both hearings.
All right, I'll address the mother again.
This one starts heavy. A mother storms in a court with disturbing claims about the father's violent past and how he's treating their child.
Again, and ask, you state in your motion that you've tried to get emotional support set in place for Easton, such as play therapy, but somehow the petitioners thwarted that?
In our parenting,
if he needs therapy, why don't you just put him in?
Well, in our parenting plan, we stated that we have to address both of those together and state whether or not we both agree to that. And I have proper documentation on our Family Wizard app that shows that he did not want to proceed with any of that. So I was unable to put him in that therapy. And that is why DCF also has been contacted due to a lot of the emotional damage that Easton has been encountering the past couple of months.
Your Honor, my client does not object to therapy and actually looked back through the Our Family Wizard messages to find where she was referring to in her motion and could not find a time he objected to therapy. So if that's the court's concern today, he has no objection to the minor child being enrolled in play or other therapy, whatever is age appropriate.
Where are you proposing that this therapy take place, Cassie?
I've actually been speaking to a place over in El Dorado, and
Place
they are
in El
actually would
Dorado?
like to.
I was
Yes, they
wanting
would
more
like to.
specifics than that.
Yes, I have it, Your Honor.
Okay.
Let me just grab that real quick. Because they just spoke to me yesterday and wanted also me to kind of step in and have a conversation as well. It is called the Sunlight Child Advocacy Center.
And they have an actual therapy program that you believe would be beneficial to your son?
Yes, Your Honor. It's an advocacy center for families. They actually are someone that also reported DCF based off documentation and the things that I had stated. They also made a DCF report, hence why the DCF contacted me on Friday, this last Friday.
All right. You have court-ordered authority to enter him into that program, Ms. Hall?
Well, that's what I would like to seek, that due to all of this emotional damage and the fact that he is somewhat getting physically abused, plus with the other children, all the things that he witnesses and sees while in custody of his father, I would like for that to be addressed, that we do start him in that therapy, because we are seeing a lot of emotional damage with Easton right now. And
All right, well,
even
you have court-ordered authority to enter him into that program.
Perfect. Thank you.
And as I understand it, what you're seeking in addition today is an order just essentially just cutting off the father from having contact with his son?
Well, I would like for things to happen before he is able to see him again. In the motion that I also have in there is that, I mean, yes, I would like full custody of our son. I mean, I've had him majority of the time. I have proof that I have him more than 50% each month and 50% of every year that I have since we have divorced. He has been doing very well. I have a lot of documentation showing that he does not do well after coming back from his father, the things that he tells me and states that is happening at his father's house. I would essentially like full custody with visitation rights if agreed upon the petitioner. I also have put into the motion exactly where those visitation rights could take place, and based off what the petitioner could do, it could happen during the week or on the weekends. I'm also stating in here that I would like for parenting classes to be conducted with the petitioner, as well as if the PFA goes through, I would like for anger management classes to be conducted before he's able to see Easton again.
Your Honor, in her motion, she did not state that the minor child had said anything. All of these allegations about the minor child's emotional state and the minor child saying all these things are brand new as of 3 minutes ago. In her motion, the only thing she references are the allegations made by the other children and the other PFA. She doesn't make any of these allegations that the minor child has stated.
Dad's attorney tries to play it cool. Says it wasn't abuse, just spanking the other kids. But then Mom drops the bomb. DCF is investigating and she's got the receipts.
Any of these things. In fact, my client just had parenting time with the minor child just prior to this hearing.
And I would like to address that, Your Honor, because
Okay. All right, just a moment, Ms. Hall. I'm not sure Ms. Smith completed her statement to the court, so
No,
let's
Your Honor.
not interrupt her.
Okay.
My client just had parenting time with the minor child where the minor child was happy, healthy. There's videos of the two of them just doing activities together that my client has that I could show the court today if the court would like to see, but there is nothing to indicate that this minor child was in any way harmed or fearful of his father during this time. And she let him come to parenting time just last week and now is asking that the court cut off all contact and make that parenting time supervised over a PFA that's been filed in a different county with different children that my client hasn't even had a chance to respond to. And again, the only allegations that we're getting here is that maybe he parents his child in a way different than she does, in a way that's allowed by Kansas law. Again, she's referenced lots of documentation that she supposedly has and she shared with everybody else other than the court today. We haven't seen any of it, or myself. And so my client has a due process right to see those allegations and see that documentation before his parenting time is taken.
And Your Honor, I do agree with that, and I am very capable. Like, I have it all ready to go. Due to the fact that I wasn't able to retain an attorney by today, I do have one that is probably going to be able to step into this for the next hearing. I have it all ready to. But I would like to say that my son has stated that he stayed at a house over the weekend that had no furniture, no refrigerator, no bed, nothing. And they had to stay on an air mattress all weekend. My son also stated that that the petitioner asked him to say things while he was being recorded so that it could be presented in court, basically. My son also stated that he, in the past, has been fearful of his father. I have a lot of just basically, he's concerned, he's scared to go there. He's afraid of the monsters that supposedly he hears. I've been told of things that are happening in regards to making children in the garage, turn on the lights, closing the doors, playing scary music, to which my son is now scared about how beds are being moved, dolls are getting moved around to make him scared. His dad does spank him a lot of the time. He said that that it's basically just due to the fact that he doesn't want to take a shower. His dad will spank him and he's crying. They get put in the corner and have to hold things that are really heavy when the children are only 8, 5, and I think the youngest one's maybe 4, I believe. There's a lot of other things that are going on that I can continue if you'd like.
What
Dad's
type,
attorney tries to play it cool, says it wasn't abuse, just spanking the other kids. But then Mom drops the bomb. DCF is investigating and she's got the receipts.
what type of parenting time is your client currently exercising, Ms. Smith?
Your Honor, he has him every other weekend from Friday to Sunday night right now. Friday night, like after schoolish to Sunday nights.
Okay, and he just had his weekend.
Yes, so this upcoming weekend would be Mom's, and then next weekend would be my client's.
And when he is there for those weekends, are there other children in the house at the same time?
Typically, there are. For this weekend, we had a little bit of a different situation because of the PFA that's pending in Sedgwick County. But generally speaking, he resides with his fiancee Rachel. They live in the house together. Rachel has 2 children, and then his child also comes on the weekends. And so generally, the 5 of them reside as a family unit on the weekends because the PFA has disrupted his ability to be at that house. He's had to find some other housing situations in some hotels and things. While her kids are there because of the pending PFA. This past weekend is the only weekend that's been a problem because of when the PFA was filed. So it's only been 1 weekend that this child has not been with the other children.
And what would the physical environment be for the next weekend? Should this court grant weekend visitation for him?
Your Honor, we have the PFA on Thursday and my client's goal is to have that dismissed. And so my client's hope is that assuming that that is dismissed like you would want on Thursday, they would go back to regularly scheduled parenting time at the house that him and his fiance share with the other children. And so that's the goal. If not, he'll have to make other arrangements with a friend or a family member for parenting time. But our goal is to have it dismissed on Thursday.
You've actually reviewed the pleadings in that Sedgwick County case? Ms.
Yes,
Smith?
Your Honor. I represent my client in that case as well.
All right, and the allegations are he improperly spanked children that are not his.
That he spanked children that he's not the legal parent of, and there's one sentence that says he may have grabbed one of their arms at one point, which my client believes might have been when they were running in traffic or something. He grabbed an arm and pulled them back.
Not in traffic, they're impeding people coming the opposite way.
So those are the 2 allegations, that he spanked the children and that at one point he grabbed a child's arm to kind of move them out of the way of other people. And if the court is interested, obviously our argument both today and there is that none of those things rise to the level stated in Peta v. Leach, that discipline of inappropriate discipline of children. The only issue in the PFA is whether or not he had the authority to do that to children that he is a step parent to instead of a legal parent to.
Well, I'll
Your
let
Honor, if
Sedgwick
I
County
may,
Court
I'd like to also
sort that
say
issue
that
out.
I was already going to plan a motion in regards to
That what?
oh, sorry. I think we're cutting out a little bit. So
You are.
Sorry, I would just like to know also that I was already planning to file a motion in regards to the custody between Easton and his father. This just happened to pop up also while I was trying to file for the motion that's supposed to be on the 25th. Brandon has a lot of domestic violence in his past. He has several domestic violent cases plus several PFAs. I have at least three of the domestic violence and the PFA numbers. The rest of them, they're actually concealed right now, so I'm not able to do
Now
that.
it gets dark. Mom says her son's been living in a house with no furniture, just an air mattress. Even worse, she claims the dad coached the kid to lie.
To do that, an attorney or a judge would have to see those. But those are what I'm raising concern as well, that this has happened in the past. So the fact that someone has formally or just filed a PFA raises more concern for me. And that's why I asked for emergency hearing before our 25th hearing, because I don't know how Easton's going to be with his father. I just want what's best for Easton.
Your Honor, those cases were already in existence at the time that these parties agreed to the current parenting plan, and therefore we don't need to relitigate the existence of any previous PFAs. We were at an evidentiary hearing. My client would testify that most of those have been dismissed in similar situations where they've been filed against him, but have ultimately been dismissed. But regardless of whether or not they were or were not dismissed, all of those have happened prior to the last agreement for him to have what I believe is on paper shared time. So he's not exercising shared time right now because the parties have switched to a new de facto schedule. But all of those were already in existence, and she was already aware of those when she agreed to the current parenting plan.
All right. The issue before the court today is, are there such circumstances before the court which warrants what is really an extraordinary order, and that is an order which completely cuts off a parent from their child? And the court is going to rule today that there is not. While there is some grounds here for concern, extraordinary relief, such as a temporary order completely cutting off a father from his son, is not warranted here. Mr. Doherty, it appears that your parenting time is essentially every other weekend from Friday to Sunday, as I understand it. There is no reason that parenting time should not continue between now and the time that the court next reviews this case. Apparently, April 25th at 9 o'clock is already on the calendar. By then, there will at least be a known outcome of this protection case. It has some, though not controlling, bearing on what's done in this case. The court would be interested in whatever findings were made and whatever final orders were issued in that case, but the court's not going to be governed by it in and of itself. But I think we'll be in a better position to review then current circumstances on April the 25th at 9 o'clock, when the court will once again review this. And I trust, Mandy, that this was set to be a Zoom hearing as well?
Yes, Judge.
Okay. We'll review the matter April 25 at 9. Until then, I will limit, quite frankly, I'm going to limit the father's actual parenting time with the son to his every other weekend, which is apparently the current schedule that's being followed. It doesn't keep father from contacting his son if there's some sort of other communication which regularly goes on, a phone call or I don't know, other communications that might happen. But as far as actual visitation time, I'm going to limit it to the every other weekend, which will have at least one other weekend, I think, come up between now and the time of the April 25th review.
The father's lawyer insists everything's fine, but the mom isn't having it, bringing up past protection from abuse orders and alleged domestic violence.
Ms. Smith, I'm going to go ahead and direct you to draft an order stemming from today, addressing the matters which the court has ruled upon this morning, including the court's enabling of the therapy at the Sunlight CAC. Ms. Smith, is there anything else that we need to address from your perspective at this time?
No, Your Honor.
All right. Obviously, the court wants the parents to work together for the best interest of their son. I hope that there's still some means of communication between father and mother that can take place to try to work out things that make sense for this boy, who I think turned 6 this year. Is that correct?
Yes, Your Honor.
All right. Well, one factor in the court's decision today is he's old enough to report what's going on. He's not a helpless child who isn't able to communicate. I just trust that both parents are making the best possible environment for him. But with that said, he also needs to be appropriately, mind you, disciplined. You can't just let him run wild. And so there is a place for appropriate parental discipline and rules to be followed. And I don't see any reason that if he's requested to take a shower, he needs to take a shower. So I suppose there's an appropriate way to get him into the shower and an inappropriate way, but thus far, I don't see that there is a need here for the court to intervene in this situation for any type of emergency relief that was sought in the motion. So again, I just hope that parents can work together for the best interest of this child.
Your Honor, and can I also state that I have, for the past year and a half, been stating to go to mediation every time something does arise, or he has concerns with something else not really involving Easton, and he not once has offered or agreed to go. So I have documentation of that as well on the Our Family Wizard app. I've been trying for quite a while to go back to mediation to discuss things, and he has asked not to, or just won't answer me.
Do you use alternative dispute resolution before in the resolution of your issues prior to now?
Yes, we use Joy Marlin over in Wichita. And so that is who we would continue to use if she's available.
Ms. Smith, if you'll discuss that with your client here in due course.
I will, Your Honor.
Also
I'll
have
ask him.
referenced in my
You're breaking up. Now she's frozen.
oh, sorry.
Okay. You were just breaking up. I didn't hear anything you just said. So,
In regards to mediation.
well, yeah, whatever your last statement was.
Oh, so I also found someone in Andover that could possibly be a mediator as well if Joy is not available.
All right. Appreciate that information. I'm sure Ms. Smith does as well. All right. Again, we're set to review status of matters April 25, 9:00 a.m. by Zoom. And the court will be in recess.
The judge delivers a measured ruling, no emergency cutoff, but therapy gets the green light and visitation stays restricted.